Please introduce yourself to the ladies and gentlemen of the Senate.
My name is Ray Chester.
And Mr. Chester, what do you do for a living?
I'm an attorney in private practice. I'm a partner at the Austin law firm of McGinnis Lockridge.
Are you the same Ray Chester that we might have heard connected to the Mitte Foundation and issues with the Office of the Attorney General in 2020?
Yes, I've represented the Mitte Foundation since 2016.
And where is the Mitte Foundation located?
Currently, they're mainly located in Brownsville.
Okay. What does the Mitte Foundation do?
Currently, well, they were started by Roy Mitte, who grew up dirt poor in Brownsville and self-made man. It's actually a family foundation. It's not a public charity. They don't accept public donations. And for many years, they mainly provided scholarships to needy students. And in recent years, they've shifted their focus back to Roy's hometown of Brownsville, and they've developed the Mitte Cultural District in Brownsville.
Who runs the Mitte Foundation now?
Roy's grandson, R.J. Mitte. R.J. was born with cerebral palsy. You may know him as Walt Jr. from the TV show Breaking Bad. He's an accomplished actor. More importantly, he's an international spokesperson on disabilities and the rights of the disabled. He's worked with the United Nations, the State Department, United Cerebral Palsy Foundation, and he gives motivational speeches to students on anti-bullying and overcoming disabilities.
Thank you, sir. The Mitte Foundation has been disparaged somewhat over the last couple of days in regards to prior management. How long ago were those issues?
They were in the 2000s, and the Mitte Foundation received a clean bill of health in 2011 and has been squeaky clean ever since.
Has management changed since that date?
Yes, the problems were Roy's son and RJ's dad.
Let me interrupt you, Mr. Chester. I'm sorry. I'm on a time clock, and I expect they might ask you those questions.
Okay.
What I'm trying to determine is there any rational basis, given the change of management and the time frame, for the Office of the Attorney General to use those issues to justify intervention?
Objection. Objection, Mr. President, calls for speculation and improper opinion by this witness without a predicate.
Overruled.
You may answer the question.
None whatsoever.
Let me turn your attention quickly then to the settlement from World Class Holdings that we've heard in detail. What was that settlement value?
We settled in July of 2019 for $10.5 million.
After the breach of contract, what did the Office of the Attorney General push you to settle for at mediation?
Objection, hearsay.
Sustained.
Your Honor, if I may, he was present at the interactions. It's an operative fact, and it's already in the record. There is no harm from the hearsay.
I ruled.
Okay.
Mr. President, to be clear, because this may come up again, all these conversations would be privileged under Texas Rule of Evidence 408 as settlement discussions as well.
Mr. Chester, would you or the Mitte Foundation have an opinion as to whether or not you're interested in waiving that privilege?
We are willing to waive that privilege.
In that case, what would the result have been of you agreeing to settle at the mediation with Darren McCarty?
Objection calls for speculation and hearsay.
Overruled.
We would have received pennies on the dollar.
Do you have an approximate value, or do you recall the number that you were pushed to accept?
The only firm offer was...
Objection, Mr. President. Hearsay.
Your Honor, it's an admission by party opponent. It was an action on behalf of Ken Paxton by the Office of the Attorney General, and it's integral to the facts of this case.
And there is no evidence of that. None.
The evidence comes from the witness, as it always does in trial.
Stop for a moment. Overruled.
Let me do it this way, since relevant facts are already in the record for the Senate to consider. What is the end result, considering that you were able to proceed with litigation?
We are poised to wrap up the litigation. The partnership properties are under contract. Mitte stands to receive approximately $23 million.
And when you say stands to receive, Is that up to whether or not Nate Paul or World Class Holdings chooses to pay you?
No, fortunately, we're not depending on that because that would be fruitless. We will be paid out of the sales proceeds.
So the $23 million will come out of the sale of the property itself without any decision-making on the part of Nate Paul or World Class Holdings?
Correct.
Is that a delta of almost $18 million in loss if you had taken prior deals?
Then leading.
Sustain.
What is the difference between those net values and where you ended up?
It's going to be about $17 million more than we were offered when the Attorney General was involved.
Thank you. Pass the witness.
Mr. Little.
Mr. President. Mr. Chester, how much money did your client, the Mitte Foundation, invest with Nate Paul?
$3 million. Well, in these two projects, $3 million. There were some other projects as well.
Okay, but the projects that are at issue in the litigation we are here to talk about, the Mitte Foundation invested $3 million in charitable funds with Nate Paul, correct?
With Family Foundation funds, yes.
Yes, and when we say Family Foundation funds, those are funds that were committed by the family to the charity, true?
Yes.
Okay, and of those $3 million that were invested in this program with Nate Paul, it's really a private equity real estate deal, right?
It's a limited partnership.
Yeah, which we generally refer to as a private equity deal, right?
There's a slight nuance difference, but it's similar.
Yeah, it's very similar. You're in business litigation, correct?
Yes.
You've been in business litigation a long time, right?
Yes.
How many years?
Well, I've focused on commercial litigation about the last 10 years. Before that, I did other things.
Okay. I just want to make sure that I can harmonize this for everybody. The Mitte Foundation invested $3 million with Nate Paul, and they're going to get $23 million back, right?
Right. We invested in 2010, 2011. Yes, sir.
Right. So who at the charity made the decision to invest charitable funds in a private equity real estate deal?
That would have been the board at the time.
And how many years did you say you've been doing business litigation?
Full-time, 10, off and on, my whole career.
Okay. Have you ever seen a charity make a $3 million investment in a private equity real estate deal before this?
Yes, sir.
Yeah. Do you remember the circumstance?
No, and I don't think it was exactly $3 million, but I just don't think it's an uncommon occurrence. They actually had 4 successful investments with Mr. Paul before his troubles arose.
I want to make sure that the jury heard that because I don't think I heard it very clearly. What did you say?
I said that they had a total of 6 investments, and the first 3 they made money on. The 4th one, he tried to swindle them. They still made money, and now there's 2 remaining.
Okay. But the one that you're saying Nate Paul tried to swindle them on, that's the one they're going to make $23 million. They're going to make, I'm sorry, you're shaking your head at me.
I may have misled you. The last 2 are the ones that they're going to make $23 million on. The 4th one was the one he tried to swindle them on.
Okay. That has nothing to do with the litigation.
Not really, no.
So the Mitte Foundations have been the Mitte Foundation's been a long time investor with Nate Paul before having anything to do with the Attorney General. Is that right?
Yes.
Okay. During the pendency of your representation, has leadership of the Mitte Foundation changed?
Yes.
And do you know a man named Dilum Chandrasoma?
I do.
And he is no longer with the foundation, is that right?
That's right.
And what were the circumstances, Mr. Chester, under which he exited that foundation?
He was arrested in 2019 for a domestic incident. The charges were later dropped, but we immediately asked him to resign.
He was accused of beating his wife and son, I think?
I don't know the details, but it was some type of domestic violence incident.
Something like that?
Charges were dropped, though.
I see. On an affidavit of non-prosecution, I'm sure, by his family, true?
I don't know, but we asked him to retire nonetheless.
Now, by the time the AG's office intervened in your pending action, your client had spent almost $800,000 or so with you, true?
Right. Most of that after.
Objection, Your Honor, relevance.
Overruled.
Right. Most of that after Mr. Paul defaulted on the settlement, yes.
Okay, so just to be clear, your law firm charged, and I want to make sure that we have this in order. These are charitable funds that the foundation is paying you with, right?
Yes.
And you charge that client almost $800,000, right?
At reduced
Objection, Your
rates,
Honor.
since it was a charity.
I'm sorry. Objection, Your Honor, relevance. If I could take him on a brief voir dire, I would be able to establish why attorney's fees are irrelevant to any conversation here.
Mr. President, we don't voir dire on relevance. The clear relevance of this is how the Mitte Foundation uses its money. It's at issue on direct. It's at issue now.
It is also recuperated.
Overruled.
Okay. So you were charging, I believe, $450 an hour to the foundation, right?
At that time, yes.
And that's well below your rack rate of $625 at the time, right?
Might have been $715 at the time, but yes, it was well below my normal rate.
And what's your rate now?
My standard rate is $715.
Okay. And you had already, by the point the OAG's office intervened in the dispute, you had already gone through a AAA arbitration, correct?
We were just getting going in a AAA arbitration.
I'm sorry, you and I are both business litigators, so this may be a little inside baseball, but AAA is American Arbitration Association, yes?
Right.
Yes, and so what had happened was you, on behalf of your client, filed a AAA proceeding to arbitrate a dispute with Nate Paul's businesses, right?
Actually, Nate Paul filed it, but yes.
But you had counterclaims, right?
Yes, we did.
And you prevailed, right?
We won, yes.
Yeah, but to be fair, you never gave the Attorney General's office notice of that proceeding as is required by law, true?
I believe the law requires notice of a lawsuit, and there was a lawsuit, and I was a little late giving them notice.
And you were probably close to a year late, right? Something like that?
Yes. However, the lawsuit was dormant for most of that year, but yes.
I'm not being accusatory. You just didn't know.
I didn't know.
Yeah.
The judge told me, she was the former head of charitable trust, and she said, have you given the AG's office notice? I'm like, oh my God. And so I sent it the next day.
Of course, of course. So the pendency of the intervention by the Attorney General's office, it lasted a total of about 3 months, right?
Approximately.
Okay. Between us business litigators, 3 months is nothing in the life of business litigation, is it?
Well, this has been going on 5 years, so I recognize your point, but those were some crucial 3 months that cost us a lot of time and money.
Well, I want to talk about what happened during that period of time. So at some point, the Office of the Attorney General intervened, and that's, well, why don't we just go ahead and pull it out so everybody has it in the record. I'm going to show you what's been previously marked as Exhibit AG 156. May I approach the witness, Your Honor?
Thank you. Am I doing okay with the microphone?
Yes, you are.
Thank you.
Now, if you would, Mr. Arroyo, Exhibit AG 156. Thank you. And Mr. Chester, just tell the jury, when was this filed?
June 8th of 2020, 10 days after the stay was lifted.
Okay. Now I'm going to hand you a really big document.
Oh, my Lord.
I know, that's what I said too. Now, this is the transcript of the hearing on your motion for sanctions, okay?
Okay. Which one? We had about 8 of those.
You got a bunch of them, right? This one is from June 25, 2020, 17 days after the AG's office intervened.
Okay.
It's marked as AG Exhibit 13.
Ugh.
Thank you. Thank you.
Mr. Little, are you entering this into evidence?
I am, Mr. President. This is AG Exhibit 13. We move for admission.
No objection.
I was glad you say you didn't want to read it. We'd have been here for a while. No objection. Enter
Now,
0013 into evidence.
Thank you. Now, Mr. Chester, as a litigator, if the AG's office were going to intervene to help Nate Paul, your motion for sanctions and the receiver's motion for contempt and sanctions probably a pretty good time to do it, huh?
I couldn't comment on that.
Well, why don't you hold...
I'm not sure what you mean.
This is 433 pages. Why don't you just hold this booger up for the jury, if you would? Just hold it up for them so they can see it.
It's the transcript's only about a first third. The rest of it's exhibits. But
yes, and this was a lengthy hearing. You argued, you introduced evidence, offered and admitted it. True?
Yes, sir. I did my best.
It looks like you did. It looks like you did a very good job. You won this hearing, right?
I believe so. Yes.
Did the Office of the Attorney General fight for Nate Paul on any of it?
Not in this hearing.
They didn't try to keep him out of contempt. They didn't try to keep him out of discovery sanctions, did they?
Not in this hearing.
At some point in time toward the end of June, so maybe about 3 weeks or so, 2 to 3 weeks after the intervention, you were contacted about doing a mediation by someone at the AG's office, true?
I was contacted almost daily about that from the moment the intervention was filed.
And to be clear for the jury who may or may not be civil litigators, I know some of them are, mediation is just a formal settlement conference presided over by a mediator, yes?
Right. This would have been our third one in this case.
Yes, and so what the AG's office was proposing was to have the parties, the Mitte Foundation and the Nate Paul entities, come together with the mediator to see if they could reach a settlement, true?
Yes, it would have been the third mediation and we'd already settled the case. But yes, sir, you're correct.
Okay, and to be clear, you could not settle the case, correct?
Explain, please.
Yeah, you couldn't settle the case, and one of the reasons was your other SEC attorneys are, well, let me try to back into this a little bit differently. How many lawyers do you have at McGinnis Lockridge?
70 or so.
Do you have securities enforcement attorneys?
Securities enforcement attorneys, no, we do not.
Okay, do you have securities litigators at your firm?
You're looking at him.
I'm looking at him?
Yes, sir.
You're a man of many talents, aren't you? So
I know a little bit about everything and not a lot about anything.
That's great. Speaks very highly of you. So, Mr. Chester, at this point in time, one of the concerns that you had was back in 2019 when Nate Paul was raided, the SEC had someone involved in that raid, true?
That was, yes.
And one of your concerns about settling the case by the Mitte Foundation against Nate Paul and his entities was that if the SEC sued Nate Paul and got a receiver appointed, that receiver might try to disgorge the settlement. Yes?
We call that clawback, and that was a concern.
Yes, and it was a concern that you had, and a very good reason not to settle. True?
And I expressed that to the Attorney General's office on multiple occasions. Yes, sir.
To whom? At the Attorney General's
Josh Godbee and Darren McCarty.
And Darren McCarty was, well, you used a word to describe him in your testimony before the House, right?
That was...
What word
that was indiscreet.
What word did you use to describe him?
It begins with an A and it ends with an E and it has 7 letters.
Okay. But you don't have any evidence that Ken Paxton ordered him to be an a-hole to you, do you?
Other than what Mr. McCarty told me.
Oh, other than what Mr. McCarty told you, no?
Right.
Okay. To be clear, maybe Darren McCarty was just born that way, right?
Or maybe he was just doing what he was told.
But you don't know either way, do you?
I don't know either way.
I didn't think so. At some point in time, bankruptcy entered the discussion in this litigation, true?
Mr. Paul filed bankruptcy 5 minutes before the deposition of his vice president of accounting. Yes, sir.
Okay, and just tell the ladies and gentlemen of the jury, what happens when you file a bankruptcy petition on behalf of an entity in litigation?
There's an automatic stay in all litigation involving that entity.
Okay, I'm going to approach you with what has been marked as Exhibit AG 212. And while I'm up there, I'm going to give you AG 41-2 to save time, okay?
Okay.
Mr. President, we move for admission of exhibits AG 212 and 41.
41's been pre-admitted, so it's on our books.
Thank you, Mr. President.
212, any objection?
No, Your Honor. Like most exhibits, these match things we would produce on our own.
Mr. Arroyo, if you would, exhibit AG 212.
Please admit 212 into evidence.
And exhibit 212 is a letter from you, true?
Yes, sir.
Okay, and you're writing to Elizabeth Dykeman. Who's Elizabeth Dykeman?
She was a court administrator for one of the judges in Travis County District Court.
Okay, and you're notifying her of removing a briefing deadline, I guess, as a result of a bankruptcy filing. Is that right?
Yes, as we discussed, when the automatic stay kicks in, then everything stops, but the judges don't necessarily know that, so it's customary to notify them.
Okay, so I just want to be clear. For one of the 3 months that the AG was intervened in this lawsuit, it was subject to the automatic stay, right?
Right, although we were litigating like crazy in bankruptcy court.
Yeah, but AG wasn't part of that, true?
I don't believe so.
They were a notice party, but they weren't part of the litigation in bankruptcy court, true?
I don't believe they appeared in bankruptcy court.
Okay, so to be fair, you're litigating with this guy on behalf of the Mitte Foundation all over the place. AAA, state district court, multiple lawsuits, bankruptcy court.
8 appeals.
8 appeals. And all that's with charitable money, right?
Yes, sir.
Okay.
Trying to get our charitable money back. Yes, sir.
And I believe you. And it sounds like you're going to get over 7 times the initial capital outlay back, right?
Long, hard fight, but yes, sir.
Okay. And to be clear for the ladies and gentlemen of the jury, in the previous 2 months before that bankruptcy filing by Nate Paul's entity in this litigation, AG's office was trying to foster a settlement between the parties, true?
They were trying to force a settlement on us.
When you say force, they can't force you to do anything, can they?
They were applying pressure. They weren't successful, but they tried.
They couldn't force you to do anything, could they?
I'll stand by my previous answer. They were trying, but they could not force us.
I appreciate your answer, but I need an answer to my question.
Okay.
The Office of the Attorney General could not force you to settle anything, true?
No, just pressure us.
No further questions.